First of all, I would like to thank the organizers for inviting me to join this conversation, something which is even more of a privilege after following the exchange between Fred and Nahum around Du Bois, I should say. I think that more or less explicitly this paper, in a way or another, engages questions, themes, and answers that appeared in yesterday's exchanges and also today's. What I think may not be immediately apparent by the time I finish this reading, but now I think actually I hope it is that it is haunted by the question Mike Hunchard has just addressed in his paper, which is the question of the condition of possibility for global racial emancipatory projects. Before I read what has become of my rather long paper, I'd like to say two things about it. First, that this paper is in between and not yet. It is in between two projects, one that I am still completing and another one which I started as I began completing the one. In that text, in the text, I tried to take care of the one paper by summarizing some of the main arguments that I introduced in it, in the body of the paper, and by referring, and I also refer to the other in the footnotes. And this paper is also not yet because it's missing a central section, which I try to also point to in the footnotes, but about which I'm not going to say anything now this time. And the second thing I'd like to say about the paper is that if this paper sounds Hegelian, smells Hegelian, looks Hegelian to you, you're right, you should trust your senses. This paper is self-consciously Hegelian. And by that I mean that it's meant as, I hope it will be a contribution to critiques of Hegel's formulations of modern thought. But yes, I think it may be another one. How many more can we have? But I hope that this one will do something I think is necessary, which is to tease out, to try to bring to the fore that Hegelian thing that I think remains in the writings of his most powerful critics, which I call in my one project, the one I'm finishing, the transparency thesis. Now to the paper. 41 bullets discharged, 19 reached his body. Any of them could have caused the fatal wound. Which ones or one killed him is relevant. That person was already dead. How did it happen? A young male stood at the entrance of his home. At about 1 a.m., a street vendor stood at the entrance of his apartment building. On that night, a young black male stood there at the entrance of an apartment building where he resided. A 22-year-old West African immigrant stood there in the middle of the night in the vestibule of a South Bronx apartment building. 4 white males stopped their car. 4 white male cops parked in front of the building where the young male stood. 4 cops of the NYPD Street Crime Unit stopped in front of that Bronx apartment building and shot 41 times at the person who stood there. Precisely when it happened, how much time passed before the first bullet was fired, and when his body hit the ground, a few seconds, a couple of minutes, is relevant. For dying is an event. For the event, any event happens. Now, the killing of a person is not any event. Always in time and space, always situated, the killing of a person is a social event. Questions of when, where, why, and how belong to it. As a social event, the killing of a person belongs in signification and concerns the law. as the institution responsible for the preservation of collective life. Depending on the legal construction of the killing of a person, the juridical apparatus will determine the adequate punishment. I'm moving too fast here because punishment is only applicable after it is decided that the killing of a person is a crime, not an accident, not suicide, which the Webster Dictionary defines, and I quote, as an action or instance of negligence that's deemed injurious to the public welfare and the morals or to the interest of the state, and that is legally prohibited, end quote. And Hegel, in his philosophy of right, defines as contingency, as subjective willing of evil, which the universal authority must prevent or bring to justice, end quote. When the killer is brought before the law, it is not only a matter of punishing the guilty, but also of protecting the right of the dead, the killed. A crime takes place if the person is a member of the moral legal collectivity. As we know, the killing of Amadou Diallo on that February night was not considered a crime. The 4 officers were acquitted of 2 charges of second-degree murder and 1 charge of reckless endangerment. Neither a murder nor a sacrifice, the killing of Amadou Diallo is relevant from the point of view of the law, because before and after the cops' 41 decisions to shoot, before and after the jurors' 9 decisions to acquit them, he, the person standing there, was already dead. The killers were not punished because there was no life to be protected. What I attempt to do in the paper is to comprehend the killing of Amadou Diallo by situating it between these 2 decisions, the cops' decisions to shoot and the jurors' decisions to acquit them. My contention here is that these decisions indicate a strategy of racial subjection which transform acts which would otherwise be defined as a crime, a particular unbecoming subjectively determined act, into an expression of universal determinants, the laws of nature that operate in modern collective existence as it is apprehended in social scientific signification, namely what I call the scene of nature. The killing of Amadou Diallo, that which happened as 19 bullets entered his body, indicates that the racial operates as a modern political signifier, as a symbolic device that produces a particular kind of modern subjects, which include the category of person, the ethical political body standing before the agents of law enforcement and the institutions of administration of justice. I'd like to invite you to consider how the event of the killing of Amadou Diallo was resolved into the construction of blackness and brownness, and of the Bronx as signifiers of the scene of nature, of a kind of social existence ruled by violence, one in which the strategies of universal scientific reason, construct as at odds with the truly universal Hegel's historical reason, precisely the one that rules the ethical and juridical moments of modern social configurations, what I call and others call the moment of transparency. Neither Hobbes or Locke's formulations of the state of nature as that which precedes the emergence of political society and is ruled by natural divine law, nor the irrational a historical domain ruled by instincts, the forces operating in Freud's notion of the unconscious. The scene of nature captures a mode of existing in exteriority, thoroughly determined by universal, here I refer to Kant's transcendental reason, that is, according to that formulation of reason as productive, in that it always already mediates that which is accessible to representation, but which is nevertheless and necessarily exterior. The scene of nature is constituted by what's known, what may be observed or predicted, but which does not need to come into being in order to have an effect, needing neither expression nor actualization, belonging neither to time nor to space, being neither possible nor potential. The scene of nature is virtual. Whatever takes place there is already known, but does not need to exist. If existence is conceived as the multiple spatial temporal expressions or actualizations of force, of law, of reason as the living, and parentheses, self-producing and self-determining, i.e. the sovereign, close parentheses, thing, which as Hegel defines it at the beginning of his phenomenology of spirit. What's known belongs in signification. It presumes signifiers and signifieds. But here I'm interested in how it also produces closure, signification, and justification, when it provides an explanation to that which is the privilege of the living sovereign thing, namely the decision. Precisely because it stands there before the decision, always available at the moment of closure, of resolution, of signification, the scene of nature is a space of death, the horizon of life, which brings it about as it announces its obliteration. And here I am kind of having a conversation with Jean-Luc Nancy's discussion, formulation of presence, but I'm not really engaging it. But anyway, the reference is about death being defining presence. Anyway, my context here is that the ratio, the signified of the scene of nature, constitutes a modern scientific signified that produces self-knowing, self-determining, and self-producing modern subjects, the ones belonging to the scene of history, the domain of life, and also those which emerge before transparency. And I'm using before in spatial terms, only in its spatial sense. Those which emerge before transparency, which thrive in exteriority, in the space of death, where they always already indicate that which constitutes the space in which sovereign social entities emerge as such, as self-producing actualizations of life, that which the laws of society are deployed to preserve. That is, I introduce the ratio as a political symbolic device, an element of modern signification, which institutes the modern subject as an effect of spatiality, of exteriority, always already a mode of existing in relationality. But to understand how the ratio produces modern political subjects, social entities that stand differentially in relation to, before each other, requires another critique of modern thought, an analytical engagement with modern representation that recognizes not only the productivity of scientific reason, but also analyzes its consequences, the ways in which its products configure modern collective existence. Certainly, this perspective owes to post-structuralist, for the lack of a better name, critiques primarily but not only Foucault's and Derrida's of a modern privileging of interiority, transparency, transcendentality, etc. What's added here is an attention to scientific signification as a moment of production of modern representations. This recognition of the ethical, juridical effects of the deployment of the scene of nature attempts to close Hegel's distinction between civil society as the domain of particularity, of contingent subjective ends, and the state, that which in which contingency resolves into the universality of reason. I quote from Philosophy of Right. The actuality of the substantial will which it possesses in the particular self-consciousness, once that consciousness has been raised to consciousness of its universality. And that's what Hegel calls true universality, end quote. That is, what I do in the paper is to revisit the critique of the thesis of law's autonomy, its absolute universality and its openness, which is resolved anew in each decision, in which the law, and I quote Hegel again, as a universal prescription is applied to a single case, end quote. With this, I hope to add to post-structuralist critiques of Hegel's formulation of modernity as distinguished by modes of collective existence ruled by transcendentality, the moment of transparency, as a moment in which the modern social, the contingent, is recognized as always already an actualization of a transcendental, self-determined temporal consciousness. To repeat, I do so through an analysis of the kind of universality presumed instituted in scientific signification, in which, in the phenomenology of the spirit, Hegel defines as that moment in which, of reason, which does not, when it does not yet know of transparency and thrives in exteriority. And, okay, sorry, now I've lost. So I'm interested in showing how scientific reason participates in the institution of modern subjects which stand differentially before the kind of universality presumed instituted in law. More particularly, I trace how the racial as a social signified transforms acts otherwise conceived as contingent evil into expressions of universal determinants, which always already define how certain subjects appear before the law. The killing of Amadou Diallo is an event, a singular event, and as such, as Derrida reminds us in Politics of Friendship, it exceeds its conditions of possibility, a statement which is, among other things, a rejection of causality, the causality instituted by the strategies of scientific reason, that shape of consciousness Hegel names observing reason or reason at its worst. But I'm not interested, as I said before, in the event as such, but in the conditions under which it became not a crime and not a sacrifice. And here I am citing Agamben's notion of the life that can be killed but not sacrificed, but not to borrow his conception of bare life, but to write the dead. And this is as much as you hear about the dead, because this is not yet. Now, the event, the killing of Amadou Diallo, came into signification, became not a crime between two decisions, the decision to shoot and the decisions to acquit the shooter. In the paper, I tried to comprehend this resolution, this interpretation of what happened, with the construct of the scene of nature, with which I attempt to capture that which stands before, in the spatial sense again, before the event, before the decision, before this paper, of which, and that which, about which I have been continuously reminded every time I watch CNN and follow the unfolding of the invasion of Iraq by the US and British troops. As I mentioned earlier, the scene of nature is a domain of signification instituted by the racial, which here is defined as a scientific signified, a construct of 19th century science of life and science of man, and 20th century sociology of race relations, which captures how otherwise particular contingent conditions express the universal, the laws of determinants of collective existence. Now, I refuse to get into the discussion of whether the racial in its biological articulation has any scientific validity. Because I'm not interested in truth, but in the fact of signifying strategies which claim to follow the rules of scientific reason. From the start, after it happened, the killing of Amadou Diallo belonged to the field of the racial. Now, here I will refer very briefly to that thing in the paper which refers to that other project I'm still completing, but I'm not going to say much about it. And I will do so by trying to show how it foregrounds a distinction, which is an artificial distinction, a distinction between the social and the juridical moment. What I hope my brief description of what I do in the paper will show is that my project is precisely one of deconstructing this distinction. So, the political moment. The political moment refers to the protests against police brutality that forced the filing of a criminal case. It refers to the prosecution's opening statements in which it constructs each case as a case of the people of color of the state of New York against the 4 NYPD officers, and it also refers to Mayor Giuliani's argument that there is no institutional or individual racism in New York City because there are more black-on-black shootings than cops shooting black folks. And he says that according to existing social scientific evidence, statistics on crime. Now, the juridical moment here refers solely to the decision to acquit, to the court finding that the shooting wasn't a crime. In both moments, I identify the appropriation of that which I call the sociological exclusion. This sociologic is an effect of the presuppositions and signifying strategies deployed by the arsenal of sociology of race relations, which has defined racial subjection as, first, an effect of instincts of whites' natural reactions to the cultural moral distance signified in the bodies of non-whites, and also in the modes of collective existence prevailing in their continents of origin. And it also appears in the post-Second World War reformulation of the sociology of race relations, and in both its liberal and historical materialist version, which conceive of race prejudice and later racism as unbecoming social representations based upon the belief in the pseudoscientific category of race. Both aimed at the elimination of such unbecoming representations through education and revolution, respectively. My arguments concerning the sociological exclusion is first that it fails to acknowledge the productivity of the science of man, that earlier project of uncovering the universal determinants of human difference, and that the one that has manufactured the idea of racial difference that prevailed in many political national projects until at least the 1930s. Second, I argue that the sociology of race relations has also been a very productive domain of modern representation. In its attempt to map the facts of becoming racial representations, it has produced the social conditions found in the segregated space the racial subaltern inhabits as both an expression of universal determinants, as an expression of the laws operating in modern modes of collective existence, and as actualizations of the kind of social consciousness that comes into being as self-consciousness in these places. That is, its signifying strategies have produced a modern social subject marked by pathology, affectability, an affectability which is an effect of their social conditions of existence, and which is also a result of race prejudice or racism, of white reactions to the now social, cultural difference signified in black and brown bodies. Precisely these accounts of pathology produced in sociological signification constitute the scene of nature. In the political moment, the protest, the target, in the political moment, the protest, the sin of the sociological signification appears in the accusation of individual and institutional racism among the New York police. And this accusation produces in New York a political space which distinguishes between the regions in which the law as law enforcement and administration of justice operates in its protective role, and one in which the law only operates in its punitive role. Now, I read the juridical moment, the decision to acquit, as a resolution of the sin of nature, which is also an erasure of this political racial mapping brought about by the protests and by the prosecution's case. I trace how the defense lawyers built a case, provided an interpretation of the event which successfully obliterated the prosecution's institutional individual racism argument. They did so by reminding the jurors of something they already knew, that Wheeler Avenue, where Diallo resided, was a space of death, that the cops shot Diallo 41 times, that is 38 times more than they usually shoot when they want to kill you on the chest 3 times, because they were afraid for their lives. They shot in self-defense because they saw a black object, which turned out to be a wallet, we know, and thought that they had been shot. All of them, each one of them, everyone shot, thought that the other had already been shot, was very close to being dead. Now, the lawyers argue that the cops were not afraid of the unknown. They were afraid because they knew that they were in a dangerous place. From training and experience, they knew they would be shot because Soundville, the neighborhood where Diallo resided, is infected by armed robbers, rapists, drug dealers, etc. The decision to acquit, I believe, indicate that the jurors accepted the defense interpretation of the event, that the cops killed Diallo in self-defense. Now, what I also discuss in the paper is how the jurors accepted this version not because the defense strategy was so good as to hide the truth, but because they also knew that the lawyer's interpretation was true. They already knew that street, that neighborhood, the black object they may never have seen. They knew the dangerous South Bronx, what the dangerous South Bronx hides, because they knew that it is a place ruled by violence. They already knew because the products of social scientific writings of the ratio belong to the late 20th century and early 21st century common sense. They appear in the news, in the reports published in Newsweek and Times Magazine between 1986 and 1993, which I read at the end of the paper, which describe the social conditions of ghettos and barrios and the types of affectable pathological subjects they produce and actualize. What pre-exists and remains after the event of the killing of Amadou Diallo was the sin of nature, the signifying context in which the officer's decisions to kill are resolved into one element of a predetermined series of events without a beginning or an end. When the defense lawyers built their case around motive, they brought social contingency into the universal domain of the law, but not to contaminate it, but to purify it from references to racism. What that insisting reference to danger, fear, crime recalls is a sin of nature which captures a mode of collective existence which is not bounded by the rule of law, but which is ruled by another universal force, that of armed criminals, rapists, robbers, murderers. A place so violent that the law itself trembles at the core of its authorized violence. But this is not the state of nature as described by Hobbes and Locke. This is not the moment of operation of natural divine law. the law of preservation of life, which allows equally free individuals to act as its enforcers every time another individual threatens his life, freedom, and other possessions. The scene of nature is always already a social context, the terrain of affectability. As a sociological product, it assumes the universal laws of collective existence, laws of nature, the laws of nature, determine the configuring conditions and processes found to be specific of the pathological regions of contemporary urban space. It has been confectioned by signifying strategies which aim to capture that which actualize the kind of person, the ethical juridical subject who dies there.